Welcome back to the Constitutional Clarion. Now, following on from my last video on the NZYQ case, which was about the release from detention of certain non-citizens who were not able to be deported, I thought that I'd do this one on the legislative reaction to the NZYQ case. Now, in this particular case, I'm going to do it on the legislation that imposed conditions upon the visas of the released people. And I'll do a separate video, hopefully later on, about the preventive detention regime that was later introduced. Now, first of all, I just think we need to recap the relevant principles that the High Court laid down in the NZYQ case, drawing on the previous Lim case, in order to understand what the constitutional issues are about this particular legislation. So the first principle was that the involuntary detention of people will, by default, be treated as punishment and therefore as something that only the courts can do when judging a person's guilt for a criminal offence. But the second principle is, well, there are some exceptions in relation to that. So examples are detention for reasons of mental illness, detention for reasons of holding an infectious disease. And such exceptions, however, must be for a legitimate purpose and must be for a non-punitive purpose. And finally, they must be exceptional in nature, so not ordinary. Now, one exception is the detention of non-citizens for the purpose of determining whether or not they should be allowed to enter into the country, so the process of deciding whether to give them a visa. And also, if you decide not to let them enter the country, the detention of the person for the purposes of deporting them. And as you'll remember from NZYQ, if there is no reasonable prospect of them being able to be deported in the reasonably foreseeable future, then in those circumstances you're no longer detaining them for the purposes of detention, and therefore their detention will be treated as punitive, and in that case it's something that only a court can do. The executive can't. So in those circumstances, the executive has to release the people that it's unlawfully holding in detention. So those are the basic principles. As a consequence of the NZYQ decision, over 140 detainees were released into the community. Now, the government initially responded by passing a law called the Migration Amendment (Bridging Visa Conditions) Act of 2023. Now, it created a new visa for this particular group of people called a bridging (removal pending) visa, which for quite unclear reasons is abbreviated as BVR. Now, it imposed conditions on the visa holders which restrict where they can live, who they can contact, where they can go, and what work they can do. And these types of restrictions on liberty are normally imposed on prisoners, for example, who are serving the rest of their sentence while on parole, or, in much rarer occasions, on people who are terrorist offenders or offenders who've committed violent or sexual offences and are too dangerous to be released into the community. The most significant restrictions on liberty were curfews, requiring a person to stay in their place of residence between 10 p.m. and 6 a.m. in the morning, and also the wearing of electronic monitoring ankle bracelets. Now, the bill initially provided that curfews and the electronic monitoring of these BVR holders could be imposed by the minister at his or her discretion. And the explanatory memorandum stated that the minister must act reasonably in exercising this discretion, taking into consideration the individual circumstances and the risk profile of each of the visa holders, as well as community safety and the rights and protections of others. The minister's second reading speech also stressed that these conditions would not apply to all visa holders. The minister asserted that a rigorous assessment process would be undertaken to identify those individuals who pose a particular risk to the community, and that these discretionary conditions would only be imposed where necessary for the protection of the community. Now that was at 9:17 a.m. when the bill was introduced and the second reading speech was given. It was a completely different story by 9:54 p.m. on the same day, on the 16th of November. At that time, the bill was amended and passed to impose these curfew and electronic monitoring conditions unless the minister is satisfied that the holder of the visa does not pose a risk to the community. Now, other changes were also introduced, and they included mandatory minimum sentences of 1 year's imprisonment for breaking certain visa conditions, and also the creation of a separate breach for each individual day during which a breach of a condition occurs. This bill was rammed through both houses of Parliament in one day with very little considered scrutiny. Indeed, the only real scrutiny it received was after it had been passed. And that's because the Senate's Standing Committee on the Scrutiny of Bills decided it was so important that it went ahead and did the scrutiny anyway, even though the legislation was already passed. Now that committee, which is chaired by a Liberal senator and operates on a bipartisan basis, observed that the speed by which this bill was passed impeded proper scrutiny of the serious impacts of this bill on personal rights and liberties. I'm going to read to you now a little part of its report from the Scrutiny Digest, because I want you to understand it's not just me having a whinge about the terms and conditions of this particular bill. Politicians from all sides of Parliament, when fulfilling their duty to give rational and serious scrutiny of the bills that they pass, rather than doing the political point scoring or exploiting community fear, did express serious concerns about this particular bill. So this is what they said. While some conditions attaching to the BVR may be appropriately attached to the visa of a particular individual, it's not apparent to the committee that every condition that attaches to the BVR should be applied to every BVR visa holder. Nor is it apparent to the committee that a mandatory 1 year imprisonment would be a proportionate sentence for each breach of the offence provisions. At common law, it's understood that the purpose of a criminal sentence is that it reflects the objective seriousness of the offence committed and that there must be a reasonable proportionality to the circumstances of the offending. The committee went on to say, the committee is therefore concerned that the automatic imposition of conditions on the affected cohort may prove to be disproportionate responses to the community risk in their application to individual circumstances and cases. Further, the automatic imposition of conditions and the mandatory sentences for breaches of the offence provisions amount to serious deprivations of liberty. Unquote. Now, the committee also raised concerns about the lack of procedural fairness, the lack of proportionality in the penalties imposed, the criminalisation of breaches that may involve no risk at all to the community, and the lack of clarity both in the drafting and the operation of the provisions, which will make inadvertent breaches of those conditions much more likely. Interestingly, in a later debate on the 6th of December, Senator Malcolm Roberts from One Nation pointed out that the ankle bracelet condition does involve the executive government in imposing punishment. And that just takes us back to the original problem that we faced with the High Court finding that unconstitutional. So there were members of Parliament that recognised that the amendments that were being made were more likely to make it unconstitutional than not. Now, it's therefore unsurprising that there have been at least 3 challenges to the legislation so far initiated. So they are AUK 15 and the Minister for Immigration, RVJB and the Minister for Immigration, and S151 2023 and the Commonwealth. Now, it's not clear at this stage whether the High Court will take them collectively and hear it in their original jurisdiction, or whether they will be shunted off to a lower court to deal with. But so far we do, at least on the High Court's website, have the outline of submissions that were made in one of the cases, AUK 15, which shows the sorts of arguments that are going to be made. And in that case, the specific question that's going to be asked of the court is whether the power to impose the curfew condition and/or the electronic monitoring condition in the manner required can validly be conferred on the Commonwealth Executive. Okay, so whether or not the government can do this, as opposed to a court exercising its judicial power of finding someone guilty of an offence and punishing them. Now, the submissions in AUK 15 also outlined three broader constitutional arguments, and they were these. Whether an interference with liberty that's short of detention in custody attracts the principle that the default characterisation of detention is punitive. Second, whether an interference with a person's bodily integrity, privacy and dignity might be characterised as punishment that engages the limb principle. And third, whether protection of the community is a legitimate object for the purposes of the limb principle, as opposed to the protection of the community from a person committing a criminal offence that is capable of giving rise to grave and specific harm. Now, if that last one left you scratching your head, there's some context to that, so let me give that to you now. It raised some points that were made by the minority in the cases of Minister for Home Affairs and Ben Bricker in 2021. So that's the earlier Ben Bricker case. There's been at least two of them. Probably will be some more too, who knows. Anyway, so that's the earlier Ben Bricker case. And the other one's Garlett and Western Australia in 2022. And in particular in those two cases, Justice Gageler, as he then was, took the view that mere prevention of the commission of a criminal offence cannot be a legitimate non-punitive objective, but that protection from harm can be a legitimate non-punitive objective if the harm sought to be protected from by preventing the commission of the offence can be characterised as grave and specific. Now, in those cases, Justice Gordon, also dissenting, was very critical of what she called in Garlett the potential normalisation of regimes that override individuals' liberty on the grounds of legislatively asserted preventive or protective imperatives unrelated to the adjudgment and punishment of criminal guilt. So we see there at least two of the current High Court very concerned about the way these sorts of regimes are applied. While the recent authorities on preventive detention regimes concern those where the detention order is actually applied by a court rather than the executive government, they do suggest that there will be at least some judicial scepticism of the non-punitive purpose of a preventive regime, which applies regardless of whether the affected person has committed any crime, let alone a very serious crime, where the conditions are imposed by the executive government rather than a court, and where the minister has very little discretion to render the conditions appropriate to a person's circumstances. Now, according to that outline of submissions in AUK 15, as at the 27th of November 2023, 132 of the 138 people who at that stage had been released from immigration detention as a consequence of NZYQ were subject to electronic monitoring. And the minister also stated in a press conference that the curfew and electronic monitoring conditions generally would be applied across the board. Now, this suggests that at least at the beginning, there was little, if any, individual consideration of the appropriateness of the curfew or the electronic monitoring conditions to the circumstances of each individual affected. It seems, however, from more recent media reports, that formal structures have since been established to make appropriate assessments in relation to each individual. One suspects that's probably because they know they're on very thin ice, otherwise, from a constitutional point of view. So overall, what are the chances of these challenges? Well, I'd give them a fair chance. Many of the conditions placed on this visa amount to serious limitations on liberty, commonly regarded as forms of punishment. They seem to be imposed by default, unless in some cases the minister decides that she is satisfied that the visa holder does not pose a risk to the community. Now that's a very high bar to reach, because anyone can impose a risk to the community. It does not seem to involve an assessment of the level of that risk or that the risk is unacceptably high. The lack of tailoring of the conditions to the circumstances of the visa holder suggests that the purpose is actually more directed at punishment than to protection of the community. And of course, that punishment cannot be imposed except by a court and for breaching the law. Now, the outcome of any such cases will, of course, depend on a number of other matters. So the facts of the relevant case, how the decision was applied, what conditions were imposed, and how it was argued. But it does appear that the amendments made during the process of the passage of the bill were very deliberately done for the purposes of appearing to be tough rather than to protect the community in a precise kind of way that also respects civil liberties. And that means that they are far more likely, therefore, to be struck down. As a number of politicians did observe during various debates on these issues in the last weeks of Parliament, unconstitutional laws do not keep Australians safe. So, thank you for watching the Constitutional Clarion. I will keep an eye on those cases and let you know how they develop. But in the meantime, I'll see you next time. Goodbye.